I'm Olaleko Ujo. I'm the managing partner of Platinum at Taylor Hill, counsel to the Taylor family. So we're here at plot 412/420 Abule Taylor along Lagos Abeokuta Expressway under Ifakojaye local government. We are standing in front of our client's property, which was illegally taken over by Lagos State government. This property belongs to our client, the Taylor family. Our client's grandfather, E.J. Alex Kende Taylor, uh, owned 100 acres of land, which he divided among his 5 children. The firstborn is Mrs. Adeshigbin, followed by the second-born, which is Taiwo, the third-born, Kende. The fourth-born is Idowu, which happens to be the first indigenous chief judge of Lagos State. That's J.I.C. Taylor, Honorable Justice J.I.C. Taylor. That's the fourth-born. The last-born is Alaba. So while the remaining children, which is Mrs. Adeshigbin, Taiwo, Idowu, and Alaba, sold their own property. Mr. Kende Taylor did not sell the property. He handed over the property to his children. So the size of this property is described as 20.98 acres. And that is the size of the property. It was given to our clients. Our client can trace their root of title as far back as 1912. I can also say that the purported notice of revocation, which was issued by Lagos State government, listed 8 documents. The first document that was listed is dated 1912, followed by the one dated September 1938, also the February 1976, and also the deed of lease, which belongs to our client's tenants. This property housed different tenants, successive tenants, from John Holt even to Yahama. That is why the property is even known as Yahama Yard. In fact, the purported notice of revocation issued by Lagos State government described this property as Abule Taylor. They addressed the notice of revocation, which is dated March 19th May 2020. The said notice of revocation described the property as Abule Taylor, which is an admission that the property belongs to our client, the Taylor family. The problem started sometimes in 2016 when some elements who are known as Omonile in Lagos State, they discovered that the lease given to our client tenant expired. So they started creating disturbance on the property. And because of that, we caused a petition addressed to Lagos State Task Force, which is Anti-Land Grabbing Task Force. And we addressed the petition so that Lagos State could intervene and address the issue. The task force, which was then headed by the then was supervised under the Honorable Justice under the former AG of Lagos State, that's Mr. Kazim Adeniji, set up the task force to address land grabbing in Lagos State, and we had a series of meetings in Alausa. The meetings were taking almost 2 years with no results. So because of that, while we were having the meeting with Lagos State government with this so-called Monile, the property was sealed off with no security provided on the property. In the course of the meeting, we discovered that some miscreants went into the property. They broke the chain, the lock and key of the property, which is shown here. They broke the chain, they entered the place, they started stealing the roofing sheets. They looted practically all the roofing sheet of the 2 warehouses on the property. The property has 2 warehouses. It can be seen clearly. Even the current status of the property will reveal that the 2 warehouses roofing sheets were stolen. They stole transformer on the property. They removed the warehouses doors. As our client that believes in rule of law took the step, engaged our services to institute an action against Lagos State government, demanding compensation and also requesting that they should be the property should be handed over to them. And that was a step we took under Hambode. And for that reason, Lagos State government, when Sanwo-Olu came into power in May 2019, they reached out to us stating that they were willing to resolve the matter. The terms of settlement was executed by Lagos State government and our clients. The said terms of settlement is dated 18 December 2019, and they stated that they will hand over the property to us, but they will not be paying compensation for the looting, for the wanton destruction of our client's property. And we agree, and we're happy that our clients will at least will have their property back. The property was handed over to us on the basis that the terms of settlement was entered into as consent judgment by High Court of Lagos State on that same day, which is 18th December 2019, and the property was physically handed over to our client and myself. The same terms of settlement was executed on behalf of Lagos State by the then AG of Lagos State, which is MJ Onigbanjo, SAN. We were shocked, perturbed, and amazed when we discovered that the Lagos State government, subsequently after they handed over the property to us, after the executed terms of settlement, which culminated to a consent judgment, they issue a purported notice of revocation, which was pasted on this property sometimes in August 2022. Again, our client, who believes in rule of law, engaged our services again to institute an action against Lagos State government, demanding that, as required by the Constitution, even though the Land Use Act empowers a governor as the head lessor, or see them as the head lessors on land in different states in Nigeria under Section 1 of the Land Use Act. Even Section 28, 29 of the Land Use Act makes provision for compensation. But the most important thing is that the Constitution, which is the grand norm, we call it grand norm, the Constitution under Section 44, subsection 1, recognizes that payment of adequate compensation must be paid before the government can decide to compulsorily acquire the property. Compulsorily acquire means that taking steps to taking physical possession of the property. As you can see here today, Lagos State government has taken physical possession of the property without paying 1 naira as compensation. We did valuation reports on this property. The property has last sometimes in 2021, when the valuation report was done, is valued as over 8 billion, almost 9 billion. Because of the exchange rate and the inflation rates, this property we are standing in front is worth over 10 billion naira. Now, the Lagos State government, we took Lagos State government to court again, demanding that compensation should be paid. We also demanded that if they cannot afford to pay our client compensation, the property should be reverted to our clients. The property should be handed over to our clients, which is the alternative prayer. And we felt that Lagos State government believes in rule of law. They caused their director of civil litigation to represent Lagos State government in that matter. The first step they took was to file an application which we found very frivolous, a plenary objection in the court saying that the court lacks jurisdiction, that the action is an abuse of court process. We responded to it stating that the matter is not an abuse of court, the action is not an abuse of court process. The application was dismissed by the court. They filed another application, which was later also dismissed. They brought an oral application. The oral application was dismissed. They saw that they could not have their way in court. What they did next surprised us. They took step, the AG of Lagos State, Onigbanjo SAN, caused a letter addressed to the CJ, that's the Chief Judge of Lagos State, that the file should be withdrawn from the judge. The ground they stated is that even though they will be paying compensation, but they were not sure of who they will pay compensation to, because they believe that there were different people who are having adverse claim. As I mentioned before, the said notice of revocation that was issued by Lagos State government listed all our client title documents as the owner. There is a consent judgment of Lagos State government, which is a product of the terms of settlement that was executed between Lagos State government and our clients. They brought tax force men and forcefully took possession of the property sometimes in October 2022. The CCTV camera footage will show the specific dates they took possession of this property. Now, the file were sure because the action was commenced under fundamental human rights enforcement procedure rules, which does not even entertain consolidation of matter, because they also stated that they intend to consolidate the matter with other matters which were filed by different people which have no direct relationship with the matter before the court. Because the matter before the court is clearly saying that there's a consent judgment between our clients and Lagos State government. With that consent judgment is subsisting, binding, and enforceable against Lagos State government. We are saying that by virtue of that consent judgment, is either you have hand over that property back to our clients, or you pay our clients adequate compensation as required under the law. Because the steps Lagos State government has taken in this regard is an affront to the clear provision of Section 43 of the Constitution, which recognizes that every citizen of Nigeria shall have the right to own and acquire immovable property. This is an affront to that clear provision of the Constitution. We discovered that the CJ honored the letter, withdrew the file from the judge. Since the matter has been withdrawn since 14th March 2022 and 2023, it's almost 2 years the file has been withdrawn. The file has not been reassigned to any judge. We believe justice for Taylor is not just for the Taylor family, it's for those who are undergoing similar situation in Lagos State. And we feel that Lagos State government, if it believes in rule of law, we do the right thing. It's very simple. You cannot disobey an express consent judgment. You cannot disobey express provision of the Constitution. The Constitution under Section 1, Subsection 3 clearly states that even if there is any law that permits Sanwo-Olu to take over this property, that law can never be in conflict with Section 44, Subsection 1 of the Constitution, which permits prompt payment. That's the usage of the Constitution, the wordings of the Constitution. Say prompt payment of adequate compensation must be made to the Taylor family before you compulsorily acquire the property. In view of the fact that there are plethora of documentation, title documents, consent judgments, we clearly demonstrate the owners of the property. It is our demand this morning, gentlemen of the press, that Sanwo-Olu, Babajide Sanwo-Olu, if he believes in rule of law, he should do the needful by observing the rule of law. It's either he pays adequate compensation, or he leaves the property, moves to another, or he hands over the property to our clients. In fact, under Ambode's government, the steps they took was that they wanted to buy the property from our clients. That is what a responsible government should do. A responsible government should not take over people's property that have documentation, registered title documents with same governments. Our client has never defaulted in paying land use charge in respect of his property. Our client has never defaulted in paying ground rents. In fact, before they took over this property is insured. It has insurance. There's a comprehensive insurance covering the property. So how do you expect an ordinary person to have faith in Lagos State to buy a land with the faith that that same property will not be compulsorily acquired or purportedly compulsorily acquired by the government without paying a kobo as compensation? Thank you very much.